want to thank everyone for coming out today for our presentation, A Graceful Exit on Business Continuity and Exit Planning. My name is Roxann Smithers with Smithers and Umewabo. We are a full-service law firm for entrepreneurs and business owners, providing litigation, dispute resolution services, corporate law support, as well as employment law and employee benefits. And we're very excited to have partnered with Robroy Wiley of Smart Plan Investing to give you guys a little bit of information today about what you need to be thinking about to prepare to exit your business. And we've looked at three main topics that are the primary ways that you're going to exit your business. And that is the sellout, preparing your business for purchase, the cash out, preparing your business to fund your retirement, and the peace out, preparing your business for an involuntary exit. We both have a real passion for working with business owners, working with entrepreneurs to help them progress their businesses and also help them to make sure that their business provides the lifestyle and the life that they want to have. You have to take into consideration that exit planning also improves the value of your business while you're in your business. It's not something to think about right when you're ready to exit, because you can't necessarily always predict when that's going to happen. It helps you to turn what is often a job into an actual business that can stand on its own. And that is the difference between creating income for yourself and creating wealth for yourself. So we want to thank everybody for coming out today. Robroy and I are going to toggle back and forth as we go through these topics. Feel free at any point to ask us questions if you have them. We're going to hit pretty much four main topic areas under our scenarios. So we're going to give you a little bit of advice about management strategies. Robroy is going to give you some advice in terms of the financial strategies you need to take into consideration. I'm, of course, going to give you the legal strategies. And then throughout the presentation and at the end of each section, we'll give you some examples that we've seen with clients that we've worked with or situations that we've seen in the public sphere that kind of highlight the issues that we're looking at. We've got a little bit of information about ourselves. We're very excited. Robroy is incredibly accomplished, financial planner and financial advisor. And we're going to start with the sellout, preparing your business for purchase. One of the things you need to think about is when sellers plan ahead, there are small and easy changes they can make to add value to their business. By failing to plan, many of these business owners are leaving money on the table. That's the key to this. The decisions and the ideas that we're going to bring forth and the advice that we're going to give you adds concrete value to your business monetarily and can also add value to your life as a business owner. So we'll let Robroy get started.
Okay. Well, thank you, Roxann. As Roxann said, I am Robroy Wiley. I'm an investor coach and I'm a business exit planning strategist. So my goal is to work with the business owner to maximize the value of their business, but also to minimize the risk to their personal and business assets throughout the process. And to give you kind of a scope of with exit planning, it usually takes anywhere from a minimum of 1.5 years to 3 to 5 to 7 years. The owner really needs the goal to become inconsequential to the business, that if the owner is removed, that the business operates on its own. The reason for that, as we go through the different exit scenarios, if you are selling it to a third party, more than likely it's going to be either to a private equity firm or to a family office. Those are the two key players in that market, and they do not want to have to run the company. They expect that whatever they purchase, that the company is going to run itself and be able to sustain it and grow over time. And then also with exit planning, it's kind of interdisciplinary as far as the different key players that come into helping the business owner planning it out. So you have your insurance person, your estate planner, your business attorney, also somebody like me, financial advisor, or also your CPA and accountant. Those are usually the main players. Also your business evaluator and or business broker, or also your commercial banker, who would be somewhere in the process of facilitating with the sale. Won't really discuss the other two options, which are transferring to a key employee or transferring to another family member. That is a kind of a different ball of wax as far as those transitions. But really with management strategies, I want to share with you a story of actually two construction companies to give you a contrast of how one used exit planning to benefit and maximize the sale of her business, and how one who decided that they were going to go alone and face the consequences of just doing it on their own. So they're both construction companies, and one was owned by Wendell Heath, and the other one was owned by Aspen Taylor. Both in non-competing markets. However, they're both valued at $5 million, and both owners wanted to exit out of their business at $8 million. So both had been in their respective businesses between 25 and 30 years. So Wendell Heath, he mentioned every year to his CPA that he was planning on exiting his business at tax time. And she would recommend, hey, at some point you need to transition your business entity from a C Corp to an S Corp. And he was like, well, I'll get around to it at some point. And he bought lots of equipment, was working 60 hours. Aspen Taylor, on the other hand, she mentioned it to her CPA. Her CPA said, you need to get a business exit planning strategist and help you coordinate all this. And the business exit planning strategist came in and helped her get a management coach to assess her management team. Also to set up how her exit through the 5 to 7 years that she had planned out, how to deal with the transitions that needed to happen. She wound up actually acquiring 2 smaller construction companies, which added value, and we'll talk a little bit later how that helped her. And then both of the construction companies went through the 2008 economic crisis. So Wendell Heath had to lay off most of his employees, and his equipment sat still for most of that time. Aspen Taylor, because she had implemented a lot of the financial strategies and she weathered that time, and she didn't have to lay off as many employees. And that when she did exit her business, she sold it for $15 million and received $10 million post-tax. So working with planning out and implementing the exit strategy really helped her exit on her terms, but also to give her the amount of money that she wanted out of the business. So that's why the first point is building a team that can survive without you. Essentially, that your management team is very strong and can make decisions and handle client issues or situations that arise without really having to consult with you or having the owner needed to be in there fixing the problem. Also, too, Aspen Taylor actually wound up reducing her amount of hours over time down to like 30 hours per week. Interesting enough, most of the time when an owner starts to plan and work with an exit planning strategist, we have a tendency to wind up reducing the business owner's hours in the business, and also wind up increasing their revenue, because they start to look at the business and their exit as a fuel to kind of a destination to increase the value of their life. The second point, build a clientele that can survive without you. So what that really essentially means is that the clients aren't attached to the owner, that they have the relationships with both managers and with employees. when a third party is going to come in and possibly buy the business, they're going to look at your clients and they're going to determine statistically, what percentage of them will leave when the business transitions. If they are leery or see that, well, one of the key accounts is attached and taken care of by the owner, they may either possibly lower their offer or decline because they know that either if 10 or 20% of the revenue of the business is going to go down because that client would probably more than likely leave. And also to build processes and procedures that the manager's employees can systematically replicate, having a standard of procedures. Roxann will talk, I know, a little further about more in detail on that on the legal side, but having a system and procedures that the new owners can see how the business is able to generate the revenue that they're doing, and that it's easy for managers, employees to facilitate and I want to say copy it, but to follow it. Does anybody have any questions? No. Okay.
No, go ahead.
Okay. So don't hesitate to stop me if you have any questions. So on financial strategies, if you remember, Aspen Taylor had acquired 2 smaller construction companies because to increase value, one of the recommendations, not all the time, but is to acquire other companies to build up your value, build up your clientele, also maybe sometimes to secure technology that you may not have access to or it's proprietary to one specific business that you want to get your hands on and that will increase the value of your business. Or they may have processes that are very specific to their business and to their clientele that are unique and that you want to pull those, own those processes. It also helps to increase the transfer or build up the value in the business for where the owner would like to sell the business. And then also making sure that cash flow is a priority. That is one of the items that the owner or the buyers are going to look for. A very consistent cash flow in the business, and will the cash flow continue over the next year, 2, 3, 4, 5 years. Also, one of the interesting things is when it does private equity or a family office makes an offer on the business these days, they have already done their return on investment. So if they offer you, because in the past I've heard from some business owners like, I didn't realize that they were going to offer me so much amount of money. It used to be owners overestimated what their business was worth. Now it seems to happen that they're kind of underestimating what the actual worth of their business is, and they're getting offers that are way higher. And one of the bankers who was facilitating one of the sales asked the private equity firm, he said, after the sale, because I didn't want to say this, but I thought you guys overpaid for that business. The guy says, no, we got a return on investment in 6 months. We already knew what that business was going to generate, and because they made not a ridiculous offer, but they offered the owner $17 million, and he was willing to sell the business for $8 million. And when they put it on the auction block, they were like, "What? That's crazy." So they've done their due diligence, and they know what the return on the investment is going to be. And then one key element, of course, is planning, because along with the financial strategies and working with the owner, and I'll touch on this in the next segment in cashing out, dealing with retirement strategies there. you're wanting to plan out how you get closer to your goal. So, any questions so far? Check. Yes.
So, this might be a stupid question.
Oh, no.
I have no idea. But you mentioned about acquisition of other companies,
Mhm.
growth. If you're sort of on the other end of that, and is there value for yourself or for your company to be acquired in some way?
Yes. Yeah, it can be. I mean, that would be could be a part of an exit strategy too. That if your goal is, I want to be acquired by a bigger business, and you have in mind 3 or 4 players that are bigger in your market, and you want to set yourself up. In some cases, too, relationships will get built between the broker, the business, and those potential bigger players in the market, so that when the business owner decides, hey, I want to sell, they already know, okay, we've got three possible buyers. We'll call them first before the business is, I don't want to say placed on the auction block, but a lot of them dealing with private equity go on an auction system to see who gives them gives the highest price. Being acquired also, the process when they start to do their due diligence and compliance, it can be and this is where a lot of times I come into play, because I'm doing a lot of whole handing with the owner, because they will dig into your financials, talk to your management team, and it's a grueling process. That time period before the sale actually happens, I will tell them, just think of the amount of money that you're leaving with, what you can do afterwards. Just get through that process. So, hopefully that answered your question.
Well, so that was more the
Okay.
exit strategy, right?
Yeah.
So, but there's no acquiring and then you continue in the business.
You can.
Oh,
You can. There could be a strategy that they either keep you on as like an employee or a consultant. In some cases, if the owner's name, brand, or the image is centered around the owner, they will do either some type of licensing agreement or work out where they can use the owner's face or image or brands in the marketplace, pay the estate a royalty or the person a royalty, or they might say, we want to buy your company, but we would like you to, work 20 hours a month and come in and consult, because we know that you have the expertise and the skills for whatever particular part of their business. So there are other avenues. There's a little more straightforward with an exit. So I'll turn it back over to Roxann.
All right. So once you've sort of thought about the management strategies that you need to take into consideration and the financial strategies that you need to take into consideration, there are obviously some legal considerations and planning that can be done in advance, as well as things to contemplate once you're actually in the process of a sale, whether it's a full sale, a partial sale, you're going to stay involved in some form or fashion. One of the big things for people to make sure that they understand are the differences between an asset purchase and a business sale. I've seen with clients where they think that the individual is interested in purchasing the whole business, lock, stock, and barrel. If you think of it as a house, they're going to come, they're buying your house, the furniture, they're buying everything that's associated with the home. Whereas oftentimes a savvy investor may be interested in what's called an asset purchase, which means they're going to kind of cherry pick the best parts of your business, purchase those items, and either incorporate them into an existing business or start a new entity. They may do that because they want pieces, because they're planning their own exit and they're just adding value to their business. They may be looking at whether or not there are a lot of liabilities associated with your business. And so they don't want to take all of that on, and they just want to take the best parts. And that's more of a think of that as an estate sale. They're coming into your house and they're going to take the sofa, they're going to take the refrigerator, they're going to take those things. They're not going to take the rickety car in the garage, but they will take the lawnmower because it's new. So that's sort of the difference between an asset purchase and a business sale, and understanding those differences because they are critical. So you want to understand, one of the big things that you particularly have to understand with an asset purchase, which is what happens a lot of the time, is what happens to realized and potential liabilities. Those can be outstanding bills of the business, or those can be potential legal claims of the business. Something you'll hear a lot, both Robroy will mention it and I'll mention it, is a process called due diligence. And that can be a time period either before an offer is made or while you're in this, sort of call it an engagement phase, where you're still kicking the tires. You may have a letter of an intent saying we're interested in your business, but we want 60 to 90 days to ask questions, to sort of get in there. Even if you put a contract on a house, I like the house analogy. It's that inspection period where they go in and see if you've got termites, if that stain on the wall is from a leak or if it's just a stain. Look at the floors, the things like that are going to happen. During that time period, whatever information they gather can either bring the price up for your business or bring the price down for your business. As you've seen, if you've ever purchased a home, particularly not a new construction, if you've purchased an existing home or sold an existing home, those things come into bear. You'll want to make sure that there's an understanding of what is included and what is excluded from that sale. Those liabilities, as I said, could be a legal claim. If you are in the midst of litigation, either as a plaintiff or an attorney, either as a plaintiff or the defendant, whether or not the company is going to maintain that and the new buyer is going to take over that claim, or if that's something that you're going to have to take over and maintain on your own when the sale is complete. That's something to think about, and that can also impact the price. If you're in a business where you have potential liabilities out there, you're selling a product or you're providing something else where someone could realize an injury down the road and there's a certain amount of time that they have to bring a legal claim against you, the purchaser is going to want to know that, and they're going to have to figure out, as part of the negotiation of your deal, how to handle those claims. If they buy the whole business, are they going to be liable from the date of the purchase forward for any existing claims? Will you have to maintain liability for those? Will you maintain insurance for those? There are different strategies, but these are particularly important questions that need to be thought about when you are either doing a sale, a wholesale sale, or an asset purchase. So there are legal factors that are going to add value to your business in a sale, and there are also things that add value to your business on a day-to-day basis. Favorable contracts that are assignable by the owner. So those can be, I've got 3 types of contracts that we can be looking at. Those can be your employee/consultant contracts. Those can be your customer contracts and your service provider contracts. So you'll be looking at, during that due diligence period, they may want to see if your business is service-based and you have contracts. Well, the key thing is, do you have contracts for people in all of these positions? Yes, value up. No, could be value down. And then what's in those contracts? If you have favorable pricing with either a customer or a service provider, what's the term for that? Are you under a year contract with them, a multi-year contract where that price is locked in? Because as Robroy mentioned, the investor or the purchaser is looking at whether the revenue that you're projecting in your business, how that's going to hold out when they purchase the business and you either leave or you reduce your role. And some of that's tied to whether your costs are fixed in your service contracts and whether or not your revenues are guaranteed to a certain level because you've got customers locked in for a certain number of years going forward. And then whether or not you've got key employees or consultants under contract. If your business is based on working with independent contractors or you have delegated properly a fair amount of your work to employees, or you're planning to do that. You want to build up a business that's going to have employees. What are the terms that they're under? What are the limitations on what they can do in terms of leaving with your information, in terms of communicating with your customers if they're no longer your employee, and in terms of competing with you once they have been with you for a while and understand sort of your secret sauce. Whether or not you've got them secured can add value to your business and be attractive for a potential buyer. On the same point, your intellectual property. If you have anything that you created, whether it's a product or a process that is patentable, whether you have trademarks either on your name, your logo, recipes, any sort of things that you do that can be trademarked and that are value, or even if you copyrighted your materials, and if you are, if you're producing written materials or other artistic materials, if you have protected that information and those assets, that adds value to the business and adds value to your asking price. And that also protects you as you are operating in your business going forward at all. So you want to make sure those pieces are there. And part of that key is if you have developed those assets before you started the business, and so you may have gotten a patent and the patent's in your name, those are the sort of legal cleanup things that you have to do where you need to transfer ownership of that patent to the actual business. An investor or purchaser is going to want to know that that's an actual asset of the business and not your personal asset. Otherwise, you've got to transfer that, you've got to do a license, you've got to handle those sort of things. And those are things that people forget about until the last minute. It's like, oh, wait, we got to make sure we transfer this, or we've got to do a license agreement or something like that to make sure it's something that's actually owned by your business. Then the cleanup items, making sure that your corporate documents are in order. Some basics that a lot of people miss. Are you in fact incorporated? Do you have your operating agreement or your bylaws, depending on whether you're an LLC or you are an S Corp or a C Corp? Do you have a partnership agreement which lays out the structure for how your business is maintained, how a purchase can be done, how you can exit the business, how your partners or anyone else can exit the business? It's important to have bylaws and to have an operating agreement, even if you are a solo business owner. It's still something that you want to have and that a purchaser is going to look at and want to know about. Let's see. Factors that can reduce your value. So we said the converse of everything that I said that are positives for the selling of your business, there are things that are going to impact your value in a negative way. You've got those claims that haven't been resolved. If you've got letters, lawyers threatening to sue on different issues, you haven't resolved those things. Those are legal issues that can impact the value. And you'll have to either negotiate a price reduction. Sometimes the strategy is that you have to put a certain amount of the purchase price in an escrow for a certain number of years or a certain amount of time. You may have to pay for tail insurance or other insurance to cover those claims if they come to fruition. So that can leave you kind of tied up and leave some of your money tied up. Or conversely, because you're ready to sell and you want to, cross these T's and dot these I's, that may motivate you to resolve issues and settle issues that you might have otherwise let linger. So that may mean offering somebody who owes you funds, offering them a discounted rate to get that resolved, or offering to settle a claim that you think you've got a good possible defense on, but you don't necessarily have the time or the interest in pursuing that claim down the road. You may go ahead and settle that. So those are legal issues that are going to impact either the timing of your sale or going to impact the price of your sale and how much you net at the end of the day. As we said, failing to secure those employees or employers or those customers. Non-competes, non-solicitations, and non-disclosures are not just for your employees or independent contractors. You may want to have sort of complementary provisions in your customer contracts so that your customers aren't sort of ferreting away your employees or deciding that they like your service so much they're just going to bring it in-house and do it themselves and use all of your information and use all of your processes to do so. And they may see your sale as a right time to sort of make that transition. So you can also have non-disclosure, non-compete, non-solicitation provisions in your service contracts with your customers to sort of protect your business on both ends. Accounts receivable, depending on how you fund your business and how your revenues run through your business, you may have some customers or clients who are behind in their payments. And depending on how much of a leash you have given them, that can impact the value. If those are good credit-worthy clients that have the funds, that's going to be something that's a little bit more attractive to a purchaser than if you've got older, more than 90 days out there and they're individuals and the rate of them paying is sort of low historically, then your purchaser is not going to want to give you full credit for those accounts receivables. So it depends on the quality of those accounts receivables, whether they're under contracts, depending on the business that you're in, whether those are secured debts or not. If you're selling equipment or some other product that you can have a bit of an attachment to until they pay, or if you're in construction and you have a place where you can put a lien or a bond, those are different types of debts or accounts receivable than unsecured, where you have provided a service already and you're trying to get paid for that service, or you've provided a consumable product and now you're trying to get paid in arrears for that consumable product. So those are even things to think about from a management standpoint when you're thinking about how you manage your cash flow. Are you paid in advance or are you paid as you go so that you don't have a lot of bad accounts receivables? And then a final piece is any encumbrances that you might have on your assets. So that means if you have equipment that's financed and there's a lien on that equipment until you pay off that debt, those are things that'll have to be cleared up when you sell. So you'll have to factor those in. It's just like if you sell your house, the mortgage company wants to get paid first and you get what's left after the mortgage has been paid, and they're always sort of the third party in that dance. The same thing can happen with other assets. If you've gotten loans or financing, you've probably had to pledge assets of the business, and sometimes personal assets, particularly for small business owners who have to either provide a personal guarantee for any loans or financing that you receive. Often your personal assets are part of that package. So you want to take those into consideration and make sure that you're getting enough to resolve those encumbrances and that they can be resolved. Okay. On the legal side, some of the examples that we've experienced in terms of assisting our clients includes a client that was involved with an asset purchase and lost some value on that asset purchase because the supplier contracts were not assignable. The supplier got wind of the sale because if your contract does not have a provision that unilaterally gives you a right to assign it, then you've got to get the permission of the other party to that contract to either assign that contract or you know that your buyer is going to have to enter into a new contract. Well, depending on how favorable those terms were, your supplier may see, hey, the market's changed, I can get more for this, and want to raise your prices and raise the price on your purchaser. And so the purchaser is going to factor that higher cost to run the business into their return on investment and into their value. and they're going to subsequently want to lower their price a bit. Another situation where the client did factor in some pending legal claims and had to discount the purchase price. Their goal was to get out clean from the business. So they didn't want to have to deal with anything going forward. So in order to do that, they were willing to give a discount on the price of the business so that the new owner would take over responsibility for that pending litigation. They negotiated where they would agree to assist with the defense, help them either find documents or be available to testify, but they did not want to have any more responsibility for taking the lead on handling that litigation. And so they were willing to trade price or value on the business in order to do that. So those are some of the legal strategies that you want to think about when you are selling a business or even preparing your business to be in an attractive position. Because you never know when, as your question laid out, another business that's planning to exit might be interested in adding your business to their portfolio. And you want to be in a position where you're ready to strike and take advantage of that opportunity when it comes your way. Any questions on the legal points or some of the legal considerations that you have to keep in mind if you're going to sell your business? All right. We will move on to the cash out.
Yes, so 55% of retirees retired earlier than they anticipated due to health problems or disability, as far as cashing out of their business. And one thing I don't know whether if I mentioned this at the very beginning, there is a fact that 100% of business owners will exit out of their business. You can choose whether or not how you want to hopefully exit out of your business. So in cashing out and using the proceeds of the sale of the business to help fund a good portion of your retirement, we're going to talk about management strategies, also financial strategies, and of course, legal strategies. And I'm going to share with you a story that actually ties into one of the points that Roxann talked about in the legal side, how a key employee actually messed up a sale for a business owner. Maria Villalobos had a plumbing company, and she had built it up over 25, 30 years. She had 55 employees, and she basically told her 3 key employees that within the next 2 years or year, she was planning on selling the business and retiring. And her one employee, her one key manager, Armand, said, "Good for you. You've worked really hard." And she told him, she said, "I could not have built this business without your help." So Maria, she kind of gleaned information from the internet and kind of decided that she was going to somewhat go it alone. She secured a business person to come in and appraise her business. So they appraised it at $11 million. She actually recruited a business broker who actually found her a potential buyer. She signed a letter of intent and met with her key employees and said, "I have a prospective buyer." And Armand said, "Well, how much is it for?" "Well, it's a little north of $10 million. So Armand comes back into Maria's office 2 days later, says, "I want $1 million. You said that you could not have built this company without us key managers, and I have an offer from your competitor for twice the amount, and they're offering me a bonus." And Maria said, "No, not going to pay it." Armand left. The potential owner or buyer dropped the sale because it was contingent that the key employees were going to remain in the business. And Maria attempted to actually put the business back up for sale. And she did get an offer, but it was for $7 million, but on the contingent that you work another 5 years in the business to help build up that management team. So Maria didn't consult with a legal or even have like an exit planning, anybody in there who could say, hey, you need to have your key employees sign non-compete NDAs, put in a system that they get paid key incentives. So the longer that they stay with the new owners, they get a bonus. So there are strategies to help secure those key managers. Because one of the other things is even if none of those key employees decided to do what they did, the owners would come in, interview the key managers, the key employees, and they're going to see that there's no NDAs or non-compete or any type of strategy in there. So they probably would have backed out of the sale because that would be one of the things that they would be possibly leery of and see as a risk.
I have one quick question.
Yes.
So I've got independent contractors, and in their contractors, the non-compete and non-solicitation. Should I have them fill that out every year?
Roxann's shaking her head no.
You do not, so your question was, you have independent contractors right now and they have non-competes in their agreements. And your question is whether or not you need to have them fill those out every year. Generally, no. It'll depend on if your contract has a term and it automatically renews, then they're going to be under those non-competes for the term of that contract. Oftentimes the non-competes also have a tail end where they last for a year or 2 years following the termination of the contract, or have geographical sort of limits or customer limits. And those things can outlast the life of the relationship. The state law is going to put some limits on it. You can't totally bar somebody from earning a living, but as long as they're key and it's reasonable, they are enforceable.
So one of the things I put down on the management strategy was loose lips sink ships. So Maria sharing with her key employees or key managers about her her selling the business and her signing a letter of intent and giving them the scope of what was going on falls into, you may have faith and trust in your employees, which is fantastic to have, but you don't want to be blindsided as an owner. There is actually another story where the key employee did actually ask the owner for $1 million. The owner did actually give the key manager $1 million because he wanted to leave. He wanted to have the sale go through, and his retirement or what he received was $1 million less than what he had anticipated. And there's an opportunity cost there as far as the one not securing the contracts with the key employees, but also if you're trying to exit out of the business when the sale falls through. And then if the business goes back up for sale, majority of the time, those other buyers, they know, and they're looking for either a reduced price on the business, and you've actually bumped down the transferable value in the business. And for Maria, it was a loss of $1 million. So she had a valuation of 11 million, and she did have the potential second offer for 7 million. So essentially, she kind of lost 4 million. One of the things that Maria did not have done with the financial asset gap analysis. So this is one of the key things that I do with my clients is really what do you have now? Let's say if you have $500,000 in assets, and when you leave and you retire, and to maintain either the lifestyle or the salary that you're pulling out of the business, you may need like $3, $4, even $5 or $6 million to help you live during retirement. And we have to actually structure a financial plan into place where you're putting incrementally large sums of money away so that when you do exit out of the business, that hurdle isn't as high. Your anticipation isn't like, I need to sell this business for 6 million and hope on a wing and a prayer that I'll get it, where you want to narrow that gap as much as possible. And then you want to know how to leverage the asset benefits. One of the other things to do is the value driver analysis. So what does the owner currently have that is driving the value in their business, but what are other strategies that they need to implement to help increase the value of that business over time? So, because essentially we're talking at least a minimum, if the owner is thinking about it, a minimum of 1.5 years. Because you're wanting to go in there and really look at the components of the business. So you want to be able to get at least the maximum value for the price of your business, and also to help you minimize the risk to your personal assets. So in the next segment of Peace Out, I have a very compelling story that actually did happen to a business. So you're wanting to at least minimize the risk to the personal assets. Anybody have any questions? I'm going to turn it over to Roxann
All
for
right.
legal strategies.
Okay, so legal strategies to prepare your business for retirement. So obviously, the quickest or the simplest way at sometimes to retire from your business is the sale. So we've kind of already talked about all of the factors that you take into consideration if you are selling the business. One thing that you definitely want to think about if you're using a sale to fund your retirement is whether or not you are doing a lump sum sale of the business, meaning the purchaser is either personally has the full price or they're getting financing to pay you the full price in one lump sum, or if you're going to do pretty much an owner finance, where either they're going to give you a certain amount down at the beginning to close the sale, and then they are going to pay you over a certain number of years to finish the purchase price. That can depend on the health of your business, and that means making sure that you definitely have a business that's in a position to be able to fund those payouts over the years. Those can be flat amounts that are paid out. They can be percentages of revenue that are paid out over time. So you'll really want to look at making sure your business is in the healthiest position so that you can guarantee that you're going to get those funds down the road if you do a sale. There are some other ways that you can also, legal ways that you can also fund your retirement that are short of a full sale. You can consider maintaining a minority stake in the business so that you will continue to receive income from the business. You no longer be responsible from a management perspective. They may want you to stay on as a consultant for a certain amount of time, or have some other sort of face role. If you have been a great rainmaker, you may get paid to have lunch and go to conferences to generate business, but not have to perform in the business. There are obviously the risks associated with that. The amount is not necessarily guaranteed, and it's you're going to want to have more of a keen eye on who you sell to, because now you're investing in their ability to run the business going forward, because your retirement income is going to be tied to that. You can consider negotiating some sort of royalty payment beyond the sale if you have intellectual property or it's a ongoing sales business and maybe you're selling to somebody who has grand plans to really expand the business. You've kind of kept it small and managed it, but they're going to make it part of some larger process or larger plan, and you don't want to miss out on all the benefits of that. So you may want to continue to receive a royalty on a product or some sort of a royalty on the services, particularly if you keep key customers engaged with the business. You may want to receive some benefits going forward from that. You can also consider a revenue or profit sharing agreement. Again, you could divest yourself of all of your ownership interests, but still have a contract where you get some share of the profits or the revenue going forward. And all of these depend on the continued health of the business and the management abilities of the purchaser. From your perspective, revenue sharing is far better than profit sharing, because that means you get your money off the top. Okay? And for all of these things, one of the other things that you'll take into consideration are the tax implications. Investment income is usually taxed at a lower rate versus your regular income. Whether or not, if you maintain an ownership, you then have some options for deductions. You have some options to reduce your taxable income if the business does have losses. So those are things to take into consideration. This is why we definitely advise that any sort of exit that you're planning for your business requires a bit of a team of experts to sort of help you do that. Here's some other ways that you can fund your retirement through your business. Throughout the life of your business, you can have your retirement accounts. There are various types of either individual 401ks, IRAs. If you have a fair number of employees and you're over the federal minimums, you may come under federal ERISA laws and have to set up employee benefits as well as benefits for yourself. And those are things that you can run through your business. From a small individual business to a business with multiple employees, there are plans and structures that are available for you to think about. So that sort of retirement planning is not just for employees in corporate America. It's something that individual business owners can do as well. Another option, Robroy touched on it briefly, is if you are looking to perpetuate a family business. So you're looking to retire, but you really want to pass the business down to the next generation in your family. Key legal things that you want to make sure that you're doing. You want to make sure that you update the corporate documents to reflect these ownership changes. Oftentimes you'll have a situation where a parent has started a business, they're listed as the sole owner, but they have kids involved in the business who are sort of operating as if they're owners, but on paper they are not owners. And even when the parent steps away from actual day-to-day operations, they haven't really reflected that in the official corporate documents. So even if you're looking to pass it on to a child or a relative, or even people that you may bring into your business as investors, and you've made agreements to give them a certain percentage, it has to be reflected in the paperwork that they have their ownership interest. Your bylaws need to identify them as officers, and this impacts their ability to officially conduct business for your company. And that really comes into play when we talk about the peace out later on and the phases that can lead to a peace out. Because a peace out can be sudden or it can be staged and it can be slow. And you don't want, one of the things that your family also has to worry about is how do they get things done for the business because they're not in place beforehand. Okay. And you also, if you're perpetuating the family business, you've got some of the same issues as a sale, same documents that you'll need, same factors that will impact the value of that business.
I can add a side note too.
Yeah.
With transferring, if you're possibly transferring a business to a key manager or key employee, you're going to want to bring in a business coach to evaluate the management skills of that key employee. Reason is that 75% of business transfers to key employees fail. And the reason being is that the key employee is, one, mentally, they don't see themselves as an owner. They haven't made that mindset and that shift. Two, staff may not see them as the leader of the organization. And a lot of times, a majority of the time, to finance that type of equity position, that's done on the contingent that the owner receives either a certain portion of the revenue or a certain portion of the profit monthly. And a lot of times that drops, and then the owner has to come in, revive the business and hopefully be able to make a good outcome of it. If you're transferring it to a family member, in my case, our business is actually family owned. It's been in our family for 50 years. So I'm a little acquainted with the trying to get the exit for the transferring to the family. One of the good things about here in Atlanta, we have a Cox Family Center. So they specifically deal psychologically with the owner and transferring it to their offspring. Because a lot of times the owner doesn't want to give up the reins of the business, but it's the son or the daughter or both saying, hey, I am ready. I am ready to take on the reins. And they're like, no, I really raised you from when you were in diapers. You're still, still a little child. You may be 35 and have a master's and, have all this experience, but you're not ready. So they help really work with psychologically, either trying to get the matriarch or patriarch to make that road a little smoother in the process. So.
Yeah. One of the examples that I've seen, and this one touched me a lot because it involved a restaurant that I really liked going to, and so I feel I was personally affected by this problem. So the restaurant owner wanted to retire, but he had not formalized any of the documents for the business. Excuse me, she had not formalized any of the documents for the business. Recipes were not written down. That is the product of the business. Okay, if you can't get my peach cobbler right, what is going to happen in this world? So that's the asset. That's intellectual property. Those are your trade secrets. They've got to be available and in a place where that can be replicated if you are no longer there. Vendor agreements were not in writing. And that's, if anyone knows about a restaurant business, your suppliers, those contracts, the timing that you have to pay for your supplies, all of those are key to keeping a restaurant running and keeping that cash flow running and keeping the prices on that peach cobbler down so that I can enjoy it. Another key point was the lease was in the name of the owner and not in the name of the company. And so that is difficult if you're trying to exit and extract yourself from the business. Now, oftentimes as small business owners and new businesses, you go into a commercial space. If you sign your lease, some people end up signing their leases before they actually incorporate their business and start their business, so they will sign in their name. So one thing that you have to think about, when you're signing it, you can designate that you're signing on behalf of the business. And then if you go ahead and you incorporate your business, whether it's an LLC, a partnership, a S Corp, a C Corp, you can then very easily have a resolution that says your business ratifies that contract. And so your business is assuming and taking responsibility for that contract. You can also have, oftentimes the commercial lease may require you to provide a personal guarantee, but making sure that there's a difference between you having a guarantee and you being the primary on that lease or on that contract. So you want to then have those leases or other contracts that you've signed in your name ratified by your business, assumed by your business, and depending on if the contract has a provision that requires the other side to give permission for that assignment, that you get that permission for that assignment so that you're no longer personally on the hook for that lease when you're trying to exit your business or if you're trying to just manage your business going forward. That can be very important. Another example is a business owner that did that, signed the lease in his name personally for the business, never transferred it over, never had it ratified by the business. The business and the business partners had issues paying that commercial lease. Now this one individual partner in the business was personally liable for the back rent and for a commercial lease. And commercial leases can be particularly onerous. You're responsible for the full term of the lease. Some leases they don't even have to relet the lease when you default. So there can be a lot of things that are tied up if you're personally liable versus the business being liable for that lease. Any questions in terms of legal issues that you have to consider when you're funding your retirement? All right. Well, this is a quote we've got from Captain Obvious. 100% of business owners will die at some point in their lives. Okay. And then according to a 2006 Gallup poll, only 44% of American adults have a will. So it's a guaranteed event that only 44% of people are prepared for. Robroy, do you want to go through these? Okay.
Yes, so as Roxann mentioned, well, the inevitable, and we're going to talk about peace out, putting it quite eloquently that way, when the owner has a involuntary exit. So I'm going to share with you a story, and it's actual real story that happened to an advisor who I know 3 years back. And consequently, what came out of it was actually a great instrument that I use with business owners on helping them with, or if they involuntarily exit out of their business. He was working with a couple, I call them Sam and Martha, and was meeting with them. He was a financial advisor meeting with them, and Martha made a comment that their estate was fine, but that she was really worried about what to do with the business if something were to happen to Sam. And Sam was 55 years old and pretty much seemed to be in healthy condition. Financial advisor said, well, I'll put some things together, and over the next 6 months, we'll try to kind of figure out maybe some strategies or something. I'll see what happens. And 12 days later, Martha calls up the financial advisor and says, Sam died. Sam was running on the treadmill. He had a heart attack and hit his head on the board. And consequently, the only person who I knew to call if something were to happen to him was you. So the financial advisor had to quickly get into the business. He knew that Sam was in the middle of acquiring another entity. So thinking that the right thing to do was to tell the bank that that Sam had passed away. The bank consequently said the line of credit is closed because they consider death as default. And that left him in the position of how are we going to pay the employee salaries? How are we going to meet the interim financial obligations of the business? And we also have to get a grief counselor for the daughter because she's having issues. The son who was in the business was trying to kind of muddle through with what was going on. And they had to quickly place the wife in as the president of the business. Fortunately, she was listed as the secretary of the business, so they could speed things up. They were able to secure a line of credit to help pay the employees and even, whatever incoming accounts payables that were needed to be paid. But really what came out of it was a business continuity instruction communication manual. And this is something that I work with on the business owner because it goes into great detail as far as if something were to happen to the owner, who gets alerted and who takes the leadership in the business. But what more or less also, what to say to clients and vendors. They're very quick to call up with their condolences, but a client may be wondering, am I going to get my product? Who's going to be taking care of it? Vendor might be wondering, when am I going to get paid? And also, consequently, what happens if your vendors or your competition gets wind of it and they start calling your key managers and your key employees and actually recruiting them? It did actually happen in this instance. But going through this manual as far as if you're in the process of acquiring another business, whose name is the line of credit in? Who are all the key players, the attorneys, the CPA? Where are all the legal documents for the business? Where are they at? also dealing with lines of credit and who is going to take on the responsibility. Is it going to be 3 or 4 people in the company that are going to take on the owner's various jobs and duties that they did? And then who is going to manage all those key client accounts during the process? And because you want to try and retain the business value, especially through your employees, because they're going to be the ones that are going to be speaking to the clients and to the vendors. As we know in this social media, digital world, excuse me, news travels rather rapidly. And then also dealing with securing information, dealing with even cybersecurity. So the Atlanta was hacked, and so dealing with who is actually even going to be responsible for that and the owner in the organization to make sure that client and vendor information is secured also. And designation, of course, I mentioned this already, but client ownership, your key clients, who takes on dealing or managing that relationship in the business. Because you really do want to retain that value, especially as an owner, if you're thinking that the business is going to help either pay for your spouse's retirement or help in the future pay for even maybe education for the children, or whatever the revenue or the profit of the business, whatever the plans, you want to try to minimize that risk. Also, you don't want to have the personal estate to have to cover the business expenses. In this case, the life insurance policy on Sam was $3 million. And they had to take $1 million of that life insurance policy to cover some of the expenses and the acquisition of the other business that was going on. So if the financial advisor had known that beforehand, would have recommended that the business have some type of key man insurance in place, which is something that I do with my clients, because that helps give a cash flow for helping if you have to bring in somebody like a temp or meeting responsibilities. It gives you the cash to help maneuver during the time and to get more or acclimated on how the business is going to move forward. The family will not be emotionally available. So if you think that your spouse is going to be gung-ho on dealing with with death and managing or figuring out how to run a business, I think twice about that. And also, if you have any pending sales, acquisitions, and loans that are contingent upon the owner being alive, as Roxann said about the sign of contracts with the owner's name versus the business. And you don't want to have you want to try to minimize the depletion of business value and the brand name. Especially if in the event of an involuntary exit of the owner, if the family is making the decision on selling the business. Because one of the things in the communication manual is who has actually expressed interest in maybe buying the business or a portion of the business. So you kind of know who to approach if that did happen. And because you want to avoid a fire sale. You basically want to avoid either having to declare bankruptcy, close the doors. And if an owner, I put it this way, if an owner at least cares about their employees somewhat, to have some type of communication on how the business moves forward, because they will be the ones that will be wondering, am I going to get paid? How is the business going to move forward if we can't meet those obligations? So now I return it back to Roxann for the legal side.
A couple things, additional points of recommendations on the management strategies from a legal perspective. In terms of the business continuity instructions, you'd want to have 2 things to think about for your business. Just like for yourself when you do your estate planning, in addition to the will, you may have an advance directive, which gives your loved ones guidance on what you want done if you are in a state where you cannot speak for yourself, in terms of how you want to be handled, how much intervention do you want to have, do you want to be on life support, these different things. You can have a version of an advance directive for your business, making sure that your key people, your family know what you want done with the business, what you'd like to have done with the business in the event that you pass away while you're in the middle of your business. Having a place where it's laid down what your plans were, things that you're discussing and negotiating so that someone else can kind of step in that place. And even having contingency plans just if you're incapacitated in some form or fashion where you cannot make business decisions or you just physically cannot go out and execute the business of your business, going to the bank, talking to customers, those sort of things, having those things in place. The best way that you can think about it, or the test that you can do, think now, if you went on vacation, would your business continue to operate without you being involved? If the answer is no, think about what are the things that your business cannot do with you away on vacation. And that gives you an idea of the areas that you need to make plans for or make contingencies for. So we think about it from a happy standpoint. But those are the gaps that you need to think about. And that can be as little as having it written down. How do you do invoicing? What's your process for taking in orders? What's your process for providing your service? Where are things? Where are the files? Where are the supplies? Just having those things available list. What are the passwords? Where are the passwords? We all have 50 million passwords. Where are they? So that if someone has to get in and do the simplest of things, that they're able to do those things in your absence. That also means that you get to go on vacation. All right, so legal strategies. First and foremost, have a will. It does not have to be the fanciest will that you've ever seen in your entire life, but you need to have a will designating what you want to happen to your assets. And your business is one of your assets. So you have to think about how you want that handled. Who do you want to sort of be the beneficiary, either in terms of maintaining and obtaining control of your business or obtaining the revenue or the assets or the value from that business if the business is no longer going to exist once you have your piece out. As Robroy mentioned, one of the things that you want to make sure you have is you can have a life insurance policy for you that the business is the beneficiary for. This does a couple things. One, if you are the key rainmaker and revenue generator for your business still, this gives a cushion of some revenue, replaces some of that revenue in the interim period, particularly if you intend for the business to continue without you. Even if you have partners and they plan to continue the business, this gives them cushion to have time to replace you, either to pay someone until they get ramped up, or to simply just replace that revenue. You can also, it can be life insurance or key person policies that are in place for that. Make sure that I said all of your contracts and your accounts are in the name of the business. Because once you pass away, your estate can end up in this limbo, and it's even more of a limbo if you don't have a will. It's to go through probate court. It takes time, and there's expense involved. And the more you are personally linked to the business, the more that process will tie up and slow down your business, and could ultimately bring your business to a halt where you intended for the business to survive without you. Your corporate resolutions, your bylaws, your operating agreements, the other documents that sort of authorize what happens for your business, they need to clarify what individuals are able to do and what they're designated to do on behalf of you or on behalf of your estate while your estate is going through the probate process. So you can designate who are the other officers of your business, particularly if you have business partners? If you are the main manager, who takes over as manager if you're not available, so that they can continue to run the business? It's depending on what they need to get done, they'll need to have proper documentation to show that they're authorized to do those things for the business. A bank may want to see corporate resolutions to certain effects if you are trying to sell things or get loans or continue a line of credit for the business. That business continuity plan or dissolution plan, particularly that's sort of having the will for your business. How do you want the assets of the business to be distributed? Do you have a key company or a key individual in mind that you would like to refer your existing customers or clients to? And what's the process for that? Will they have access to your files? Will they have access to that information? How that gets communicated? You can put that in that. You can put that in the operating agreement. You can put that in other documents for your business.
And on a side note too, dealing with businesses that are operating like on a service, like a CPA, legal, even financial, or type of service entity, there is a way to be able to formulate if something happens with a competitor or type of agreement with somebody who is a business that is like yours in another market or in your market, for they to come to terms as far as if something happens, they will help step in, continue working with clients and pay the estate or the owner a certain percentage of the revenue that's coming in. Instance, works with a CPA who had a heart attack in the middle of tax season, had this practice continuation agreement in place. And so it was a bigger CPA firm that came in, continued servicing the client's accounts and paid a certain portion of that revenue to the CPA. It also can work on if there is death or the involuntary exit of the owner, that they can come in and help with that continuity in the business.
Yeah. And depending on the type of your business you're in, for example, there are states where if you're a solo attorney and you're responsible for individuals' legal rights, that you have to file with the state who is your backup person to handle your clients and handle your files if you pass away or you're incapacitated, because there are key deadlines that our clients are going to have to deal with. But those are things that can come into play in any type of business, particularly if you intend for the business to survive after your exit and to thrive after your exit. You don't want to lose people in that transitional period, because that's where a lot of times changes are made or competitors swoop in or things like that. So you can even create a little bit of funding for your estate if you do a continuity plan with a competitor, and that they've got to then return revenues to you, some portion of those revenues, in exchange for getting your business referrals or getting your clients. That can help fund your estate. Oftentimes in either operating agreements or the bylaws, they'll designate what happens if one of the members, even if you're solo or if you have partners, what happens if a member does have an involuntary exit and passes away. Whether or not that triggers an automatic dissolution of the business and a wind down of the business, or whether or not your beneficiaries, your heirs, do they inherit your ownership interest as well as your management say in the business, or do they simply inherit a income interest in the business and they won't have a say in how the business is going to run? Or does your passing away automatically force a sale of your shares and your interest, and the business is required to then buy out your estate? And that's another reason why the insurance is key, or having those funds are available, because now the business has to figure out how to pay for your interest and pay your estate. And you can do that if they're cash strapped. You can have that insurance policy that can fund that purchase. And you can have either in those agreements or have a separate agreement that is that buy-sell agreement that dictates what happens if you pass away. So knowing that, because you may think, you've got business partners, you may think, well, I pass, well, automatically my family, my spouse, or my child is going to take my place in the business. Not if the operating agreement doesn't say that. It may force a sell and push your family out, or it may leave them in. And if you have partners, you may decide, I don't think I want my partner's spouse to be my new partner if my partner passes away. So thinking about how you want those provisions laid out in advance are often very important. As part of this, you also want to think about, in addition to the will, the other documents that, as I said, should be in place short of death. You want to have your advance directive that lays out what happens to you, but also can lay out what happens to the business, and limited financial power of attorney, which gives someone the legal authority to conduct business for you. It can be as broad or as narrow as you want it to be. And they're accepted by most businesses. You can have one uniform power of attorney. Then in most cases, businesses will accept. They'll want it to be on file with them. And that means so you can talk to the IRS, you can talk to the bank, you can open accounts, close accounts, sell assets. And you can make it as broad as you want in terms of the powers that the person has, or as narrow. And you can even do it for a time period. It's particularly good if you're just sick or you're injured and you want it to go into effect, and it'll only go into effect for 60 days, 90 days. And then if you're incapacitated further, you'd have to take other legal steps like a conservatorship if you're in some sort of long-term state where you cannot function. But those are good temporary things that you can put in place in advance if something happens and you're not available. Any questions on the legal strategies for that piece out?
I do.
Okay.
How often should you revise your business continuity plan in addition to the buy-sell agreements and those other documents that should complement the overall plan?
The buy-sell agreement, pretty much once you do it, if your decision in terms of what you want to do with your buy-sell agreement doesn't change, then once you have your buy-sell agreement or your buy-sell provisions in your operating agreement, those can last. If you do strategic planning every couple years, it's advisable to just sort of take a look at your documents and make sure they actually reflect what you are doing. I mean, as our business, we had our operating agreement, and as we were functioning, you start saying, well, we're not really doing this that way, and we didn't think about this piece. And so we, look at it and decide if you want to make any changes. But as long as it is reflecting what you're actually doing and reflecting how you want to handle things, then once you've done a pretty well thought out operating agreement or buy-sell agreement, then they pretty much are set it and forget it. If you want to change designations of individuals, something happens to someone moves, or someone else passed away that you have designated, then you may do an amendment to update that. But you don't necessarily have to do a full overhaul under any specific timeline. Any other questions? Yes, ma'am.
So you all have mentioned bylaws a couple of times, and on the operating agreement and or the bylaws, you talked about this being included. So this could go on. So just briefly, what else are some of the things that should be in the bylaws, and then what is sort of the basic difference between the bylaws and the operating agreement?
Sure.
Kind of
Basically, bylaws and operating agreements serve the same purpose. Bylaws are for corporations, so an S corp and a C corp, and an operating agreement is for a limited liability corporation. The other agreement that you're not going to see often would be a partnership agreement. If you do a partnership, either a traditional P or a limited liability partnership, then you'd have a partnership agreement, and it's basically the contract or the blueprint for how the business operates. So it identifies who are the members, who are the owners, what their shares are, how they put money into the business, how you take money out of the business, how often those things happen, It designates who's responsible for making decisions for the business, who can sign contracts, who, depending if you're manager or officers in the terms of the bylaws. It can designate what happens if someone passes or someone dies. And it can also dictate how people leave the business, whether that's selling their shares voluntarily, whether they're being voted out of the business, and how that is handled and how it's financed. If you think about your certificate of formation, which when you register with the state, you get your nice "we're formed," that's your birth certificate, if you think about it as a person. Your operating agreement, your bylaws, your partnership agreement, that's sort of the DNA. And your DNA dictates how your body actually functions. And that's sort of a good way to think about the difference between the two. But they're critical to have, because once you are trying to figure out how to handle situations, if you don't have those agreements, then you fall back on state law, which will give you default positions that you may or may not be happy with. So that's like you buy a new electronic device. The default position is what your ringer is, what your font is, what the background is. Having your operating agreement is you personalizing to the ringtone that you like, the alarms that you like, the picture that you want for your background. So if you don't do that, then you're stuck with the default positions that are in law.
Yeah, I have a story about that.
Okay. And then final, just an example, tails from the front on that. Client updated the operating agreement and the resolutions to reflect the ownership and interest and management roles of the children who were working in the business. Excuse me for the typo. Prepared will to leave his remaining interest to his spouse as interest income only. And then the operating agreement provided for the income interest by a member who inherits. So that sort of goes back to that example that I gave, that your operating agreement, your bylaws can dictate that your interest either passes fully and that person literally steps into your shoes in the business, or something short of that, or can force a sale. And it's just something to think about either for your spouse or if you're in a partnership with someone else, whether you want their spouse as your business partner if something happens to them. Robroy?
I actually have recently, can't say too much about it, but dealing with operating agreement, because I will ask my clients if they have an operating agreement in place. And you want to make sure when to really work with Roxann, because you wanted the operating agreement to be as ironclad as possible, especially if you're entering into a partnership and they are friends of yours. Seen instances where those partners have actually, behind the scenes, started another company, kind of copied what was going on. So the operating agreement really needs to be like ironclad, and that somebody like Roxann coming in and filling out those details that you don't really kind of foresee or think about. They had an operating agreement, but it was not as detailed as it needed to be. And consequently, they had to wind down one of their businesses.
Yeah. And so as we wrap up, we also just want to remind everybody that the things that you do to prepare your business for an exit are also a lot of the things that you just want to do to have a healthy business and to have a prosperous business while you're in it. It also gives you some ideas about the difference between creating a job for yourself and creating a business that can stand on its own. And as I said at the beginning, a job creates income. A business that can stand on its own, you're creating wealth for yourself. So we want to thank you for coming, and thank you for participating. And you've got your handouts. If you guys have additional questions for us, you've got our contact information. Please feel free to reach out to us. And here's our contact information again. Thank you.
Thank you.